So today I want to talk about the problem of entrapment. And not only is it the title of an article that I am borrowing from Professor Hughes, but I'm also interested in talking about it because it's one of the most misunderstood concepts. If you ask the person on the street, what are the three or four or five things that you know about, the legal profession? Entrapment probably would be one of them. Everybody seems to think they know all about entrapment. I shouldn't say all about, but that they have a pretty good handle on what entrapment is. And in fact, they really don't. Legal entrapment is what's called an affirmative defense. What that means is you have to first have been convicted of or admit to a crime or been credibly accused, either of those three, I think, and then you can argue entrapment. So the idea is you would not have been guilty but for what the police did to create a crime around you. And that's pretty close to the legal definition of entrapment. However, entrapment also encompasses or incorporates a generic or a general, or we might say a public view of what that is, which is unfairly creating a set of circumstances around somebody such that if those circumstances weren't there, it wouldn't appear that they had made any kind of crime. In fact, I'll read directly from Professor Dworkin's. He was in the Department of Philosophy way back at the University of Chicago in 1985. University of Illinois, Chicago, excuse me, not University of Chicago. And he described it this way: entrapment occurs when government agents procure the commission of a criminal act. They get you to do something criminal, by someone, who, except for the solicitation, persuasion, or enticement, would not have committed the crime. What's interesting is that Professor Dworkin writes his paper on this, and he was with I have it somewhere here, not on these papers, unfortunately, and he writes it in The Serpent Beguiled Me and I Will Eat, Entrapment and Creation of, and I can't read the rest of my writing, but that's Dworkin. And what the professor suggests is that, this is the legal interpretation, and his generic thesis is, in these many pages he writes, police need a warrant, and that is a way to rein them in. And we need to be focused on the objective element of entrapment, which I'll get to in a minute, which involves police conduct. Well, before we get too far from Gerald Dworkin's thesis, I just wanted to mention one other thing. He writes it in 1986. Very shortly thereafter, in a year or two, the Electronic Communications and Privacy Act comes in, and it is amended in 1989. And what it says is police cannot be going after you in an electronic setting without a warrant, without probable cause. It doesn't say anything about trolling being permissible. In fact, it rather suggests that it's not permissible, what we call the proactive stings, and more colloquially, trolling. Okay? It's interesting he writes this, and then a couple years later, the wording of what he says, namely persuasion and enticement, comes into federal statute. And I don't know if it was there before or not, but if you go back to President Reagan's Executive Order 12333, he specifically says, among other things, in that executive order, that police have to have a credible person involved. Of course, the courts have completely ignored this, as we'll talk about a little bit later on. So all of this stuff where they do proactive stings and they come after you and they have personae and they have very specific bait and switch, where they first go on an adult platform, pretend to be an adult, switch to a child. And somehow the idea has come across where you have a moral responsibility immediately to cease and desist. You're not allowed to be confused, surprised, amazed, And if you've been having conversations that involve fetishism or cross-dressing or just, role playing, none of those are taken into account on this platform, which is why it's so dangerous for police to be on there trolling for people and claiming that they're trying to protect children, because they count on this sort of conduct on, namely the role playing, the fetishism, the cross dressing, all these the smack talking back and forth. They count on that, they rely on that, and they use it against you in a court of law. And that's what makes the proactive approach so difficult. That's one of the reasons we're complaining about it. They go on gaming platforms. Mostly it's the turnkey system that they've developed, where they actually create criminals from people who have shown no propensity to commit the crime to begin with. People like me, but not just me. I'm just trying to be the spokesperson, I guess, and trying to get the message out. But let's go back to the issue of the entrapment. So the way entrapment works is that the courts have developed, it comes out of the Fourth Amendment, it's derivative of that, and it basically says that you can't be entrapped if you took the bait from a legitimate law enforcement investigation. Okay, not gathering of evidence necessarily, that's a different issue. Investigation of a crime in progress. So right now we have several problems. We have a problem of, if police are doing a proactive sting, they're not dealing with a crime in progress at all. They're simply trolling. They're hanging out to see what they're going to do, and rather than people sitting there thinking that they just hang out there like they do on the side of the road waiting for speeders, they don't. Increasingly, they're much more aggressive, they're involved, they set things up, they approach you first, they frequently bring up sex first, they do a variety of things. They get right in the mix of that, cross-dressing, fetishism, gaming platform, smack talking, dating. Some people are looking for lifetime companions, despite what you will hear the police say. Okay, so they get right in that mix where people are at their most vulnerable, and that's where they carve out something. So what Dworkin has said, and what will come into the ECPA later, and I don't know why necessarily, I don't know if they contacted him or he had anything to do with it, but what they will say is, in the federal statute, police are not allowed to use enticement, inducement, persuasion, or coercion. They use all four. They're not allowed to, but they do, and the courts have looked the other way. So we have a case where the courts are defending the police and the prosecutors, which what seems like it's based on this notion that we must protect the children, therefore anything goes. But if you use something, even something as emotionally charged and as absolutely necessary as protecting children, and you use that as an excuse to sideline the Constitution, well, there'll be many ways that you can use then excuses. It'll become routine. It'll become a habit. And then the Constitution has no value if you do that. So they have set up with entrapment some procedures to determine if enticement or inducement or persuasion or coercion are happening. And one is called the objective test. Okay? And the objective test basically says, would a police officer know that this is appropriate conduct? It puts the burden of proof on the police officer and on the prosecution to determine, is this something that the police seems to be more involved with pressing, or is it the subjective test where it focuses on the conduct of somebody like me caught in a sting? That's the primary difference. Of course, the courts get in there and they tinker with these things. The objective test now looks like it has a secondary component. And that secondary component is not just what a policeman would know would be sensible, logical, intelligent behavior on his part, whether he used proper judgment, but whether any police officer has ever been convicted of this sort of thing in the past. and cases have been dismissed in favor of the officer and against the defendant, the citizen that the Constitution and the entrapment clause is supposed to protect, sent down the river because we can't determine if a police officer would have known this, or worse yet, there's been no prior case where a police officer, where we've had this situation where a police officer might have known. And if there's no prior case, well, then we have to give it to the police officer. Forgetting, apparently, that there has to be a first time for something like this to happen. So that's the objective rule. The subjective rule is the one that they appear to be focused on more and more. What did you do in the process? Wise courts use a balancing act between the two, where they have to look at both. The public, unfortunately, has been trained by the police and the prosecutors simply to look at the subjective one. Well, what did you do? And you'll hear all the time from people, well, what did you do that you got arrested? Oh, I was protesting. Well, what were you doing protesting? As if protesting is somehow illegal. And actually, it's in the First Amendment. So, that's the basic sense of what we're talking about with entrapment. We get down to these 3 articles here in Dworkin. I've already says, you want to figure out what's going on. You want to get that fine balancing act, get a warrant. Now, this is what the U.S. Supreme Court said in U.S. v. California as well, some 20 years ago. There was a situation where it involved a cell phone and cell phone data, and the police officer forced the person he had pulled over to open his phone and give him the passcode. And then he found incriminating evidence on the phone. And the Supreme Court then, in a 9-0 ruling, said, you don't have any right to do that. You do not have a right. And don't forget that they seem to suggest a privacy right here as well. And again, I hope I'm doing all these cases justice. I don't want to go too long in these videos. I am trying to be compact and condensed, and I've been thinking about this particular one for some time. So you have the Dworkin view, right? You have Paul Hughes, who comes in 2004, right? Some 40 years later. And he says, Dworkin's wrong. The test is not just simply something having to do with, just get a warrant. And we won't have to deal with the messy issues of whether it's the cops or the person, the subjective or the objective view of this. We don't have to worry about defendant subjective or cop objective. Just get a warrant and that's going to solve it. Problem is, what cops are doing more and more now is they're doing illegal things to get the evidence, and then they're getting a warrant to obtain the evidence they've already got. Okay? And even people in the Department of Justice have admitted that they sometimes do that. Okay? And certainly that's in unwarranted policing without I've forgotten what the last name of it, unwarranted policing without protection or something by Barry Friedman. I don't have it in front of me. I'm trying to do this here on the fly, but I've suggested many times, I've talked about it, and he actually lists during the Obama administration where certain senior members of the Department of Justice say that, yeah, they sometimes do that, okay? So when we look at this, it's interesting that Paul Hughes says, since any proactive sting undermines the autonomy of those subjected to it, it really needs to be looked at very, very carefully, right? Proactive tactics may go too far, he says, and that creates a real problem when they create these tests, including a moral test or virtue test for people. And he says the problem is there's supposed to be predisposition for a criminal intent. Dworkin assumes that there had been mostly reactive stings, and this is in the 1980s, and that if anybody, apparently a recidivist does it again, and therefore predisposition isn't an issue because it's assumed they would do it because they committed this other crime. I'm not sure I necessarily agree with that, but that's what he has suggested. So that's fine. But here, we look at Hughes, and Hughes says that predisposition is very, very important, because how do you know then, as one factor, whether somebody would have done it? Okay, you look at my case, there's no predisposition. You look at Dr. Kilpatrick's case, no predisposition. Okay, you look at Ryan Pick's case, and you look at many other Chris's. I won't mention his last name. Matt, Mike. They don't want their last names, and many, many others. There was no predisposition. Okay, unless you want to argue being gay in one case is a predisposition, cheating on your wife is a predisposition, but I don't think anybody would argue that that would lead you to want to have relations with children. Okay, and so what's really interesting about this, it goes all the way back to Sorrell's case in 1932, which was a prohibition case. And here you had the Supreme Court then, writing for the majority of the Chief Justice, wrote, quote, "A line must be drawn between the trap for the unwary innocent and the trap for the unwary criminal. The unaware innocent person and the unaware criminal." Of course, what police have to do is say you are aware. So that's why they spent so much time saying I knew the difference between the various Alexes and Zach, and that I must have sent this picture because the picture showed up. I never admitted sending the picture. They told me I did, and I denied that I did it because I said I would never have sent a picture deliberately to a child like that. I wouldn't have done it. But they claimed I did. Later now, it's becoming abundantly clear that I didn't have control of my phone for a good bit of that time, and the phone was not secured in a Faraday bag. So how do we know that the evidence wasn't tampered with, particularly when there's some evidence that it was? So this is one of the arguments that these two psychologists, and I'll probably leave it at these two, mention that it's not simply a temptation issue or an ambivalence issue necessarily, or an issue having to do with alleged predisposition. That the police have to be held to that higher standard if they're claiming on a proactive investigation that this person surely was going to do it. It wasn't a reactive sting. They didn't have a tip, so they have to be much more certain about it. Hughes goes on and talks about this very interesting idea of ambivalence. He says, if there shows ambivalence, we might say resistance to the scheme that the police are putting forward, as I put resistance to it, as I argued with them, even as they wouldn't let me see all the evidence they had in front of me, I would say this doesn't comport with my memory. I don't think this happened exactly as you're saying. In fact, I know, let me see this, and then the cop stopped me and gave me a different phone to look at and wouldn't let me lift it up, considering that he knew that all of the evidence that was on his phone was deleted. And I had the evidence on my phone, and he was scrolling through it, setting it down and not letting me pick it up. And then asking me very specific questions to agree with him. Do you agree with me on this? Do you agree? This is what happened, right? This is the person, right? And it wasn't. It wasn't how he had arranged it. But none of that, remember, is available in the video. You can't see that going on. Unfortunately, it's only me and him. And I wish, despite the two angles that we had, neither one fully shows what Detective Bauer was doing. And that's part of the problem here. They're talking about the entrapment defense, Hughes says, has to take into account what you can see, the ambivalence of the person, okay? The creation of strong inducements to violate the law is just a point of proactive law enforcement. It would be unjust to hold people fully criminally responsible for illegal actions resulting either from resistible or irresistible temptations created by illegitimate proactive law enforcement. And he says, i.e. entrapment. I'll read that again. It would be unjust to hold people fully criminally responsible. Doesn't say irresponsible, fully criminally responsible. as they do. The police did nothing. For illegal actions resulting either from resistible or irresistible temptations created by illegitimate proactive law enforcement. In other words, if police do as they claim and they just hang back there and fold their arms and wait for a crime to happen, you wouldn't get very many crimes. And it would be very clear whether somebody did or didn't. But they wade right in the middle of it, as we have been claiming all along, and that's what makes things very, very difficult. So he suggests here that what has to happen is you have to have this sense where you have, how can you put this? He says all entrapment involves temptation and actions about that temptation. But that doesn't, the ambivalence and the resistance doesn't suggest criminality. We have people who I've been sparring with online who says, oh, well, you should have just moved away. Like Monday morning quarterbacking explains everything. But here again, both Dworkin and Hughes and others say that's not normal. That's not normal. He says, since I've argued, says Hughes, that entrapment involves tempting people, sometimes irresistibly, into committing crimes. Since all temptations are states of ambivalence, and ambivalence is a state of psychic instability. That's not intellectual problems or moral problems. He's saying it creates dissonance in your head. What am I supposed to do? What's really happening here? I don't know what's going on. Then entrapment is a practice by law enforcement of inducing states of psychic instability in legally innocent persons in order to entrap them. Maybe this is an argument that we ought to be using. Certainly we've used it not as cogently, not as articulately as Professor Hughes does, or some of these other folks as well. You know, you can go even further into Daniel Hill in 2020. He wrote an entrapment article, more recent, and he says from objection, it's called Entrapment, from objection, from temptation to objection, from moral alliance, where he talks about the moral stances that people take and how it is possible to create some measure of, moral congruence that would still provide you a reason to not be considered to be entrapped. I understand that the public who would want to convict people, who claims that this is all, word salad gobbledygook, and that if the police arrest you, you must be guilty, or as my former friend Woody has said, that, they caught you twice. They didn't catch me twice. You don't understand what you're looking at. And when you don't want to put in the intellectual time that I put into it, then you really ought not wade into it and say anything. But unfortunately, the public are voters, and they make decisions on these things. And they don't necessarily understand unless it happens to them. And then you go through the stages of grief, in effect, right? Surprise, anger, shock, amazement, all right? Rage, finally acceptance because you're beaten down because the system does not tolerate any sort of resistance. One day I'm going to tell the case of a young man out in Leesburg who had 88 cases of child pornography against him. It was nully processed over a couple of years, thrown out because the Loudoun County Sheriff's Department did not have the goods. The man in question sued them for $3 million, and lo and behold, 88 charges miraculously reappeared on his devices. Well, that's all I know about the case, really, even though I went to sentencing. But doesn't that sound a little curious that they, right away, when the police were threatened, all of them appeared again? Well, it is. There's got to be something more to these cases. People are afraid to speak out. They're afraid to look at it. And entrapment, as in my case with Judge Devine said, I don't see how you get anywhere near entrapment. As far as he was concerned, he saw everything. And he, as I said, was not paying a bit of attention to anything that we put up there. He wasn't allowing my comment to him where I demonstrated how Detective Bauer violated the terms and conditions of the use agreement, how he made the Alex and the Alex VA, how he pretended to be an actual subscriber, a real human being named Zach, in order to try to get something, anything. And the lower court had thrown that part out where they were arguing I was going after a real child, but nothing he looked at there did he see any evidence of that in his mind, despite the fact that in other cases there have been even weaker evidence of entrapment that the courts have not passed on. They've not panned it. But then again, this is a different era. And if people put the word sex out there, it very often gets more traction. And words like entrapment tend to become the subjective tests, where you, the unwary innocent, who don't have all the information, who didn't put yourself out there to go after a child, you have to defend yourself and explain repeatedly and mightily. And since they have all the cards and a near 100% conviction rate, you are bound and determined to be convicted, which reinforces the notion in the public that predation is crazy out there. It's everywhere. We have to watch our children at every moment. These perverts are everywhere out there because look what the great job the police are doing, and they get them every time. And of course, we know that isn't true. So I hope that's been somewhat helpful to clear up what entrapment is and what entrapment isn't, and also give a possibility of definitional spring to going forward in some way. The idea, I'll leave you with this from Professor Hughes, the idea of implanting criminal notions in innocent minds and seducing, quote unquote, innocent people into criminal behavior articulates a common intuition about what is morally wrong with entrapment. Namely, that it involves manipulating people's desires and intentions. Manipulating their intentions, okay? So I had an intent with an adult, manipulating it to make it appear to be a child, in order to create crime and then prosecute and punish the offender. Whereupon you get the label and the stigmata on you, as I've suggested. And then all hell breaks loose in your life, and residually for other people as well. And that's something that we have to find. So if you can, I will put the citation in the comments section, and maybe you can look some of these up. I don't have a complete citation for one, but it's worth looking at. This is Norman